And
Did you both argue that at the Supreme Court?
we did.
The two of you?
Yes, Your Honor.
All rise. The Second Judicial District Court of the State of Nevada is now in session. The Honorable Kathleen Drakulich presiding.
Thanks, everyone. Please be seated. Good afternoon. This is case number CV 21-00875. Robert A. Conrad, an individual doing business as This Is Reno versus Reno Police Department, the governmental subdivision of the city of Reno. This is the date and time set for a hearing on the state's motion for protective order. Let's take some appearances. Mr. Busby.
Good afternoon, Your Honor. Luke Busby, appearing for Dr. Conrad, who's bringing the court to
Dr. Conrad, it's nice to finally see you in person. Mr. Dunagan.
Mark Dunagan from the City Attorney's Office here on behalf of the City of Reno, the Reno Police Department.
Thanks, Mr. Dunagan. Counsel, let me give the procedural background on this. March 4th, the city filed its motion for a protective order. On March 28th, Mr. Conrad filed his opposition to that motion, and then on March 11th, the city filed its reply, and the motion was submitted to the court. But then also on March 8th, Mr. Busby, on behalf of his client, filed the objection to and request for hearing on March 5th, 2024. And I set this for today because Mr. Busby made a point of telling the court that I think one of the operative dates that the parties are concerned about is that the sentencing in a criminal case that's pertinent to this case is coming up April 2nd. Mr. Busby, correct?
That is correct, Your Honor.
Okay, all right. And my plan is to get the order out as quickly as I can with that in mind. All right? Mr. Dunagan, this is your motion, so I'm going to give you the opportunity to make the argument first.
Thank you, Your Honor. As you know, the city has moved for a protective order. In motion, the city briefed the standards for that, which give broad discretion to the trial court to decide when a protective order is appropriate and what degree of protection is required. Now, instead of opposing the analysis that was in the motion, the petitioners mostly just sort of threw up the objection of a prior restraint and did not offer any briefing on the standards for a protective order, Bradshaw balancing, or on the city's argument that the MPRA is unconstitutional as applied. So I want to say that from the outset, that any new authority that we hear today, I haven't had the opportunity to brief that because the opposition to this motion just doesn't address those arguments.
Okay.
The motion offered two bases for the protective order. The first is that the Bradshaw balancing test under state law supports it. The petitioner has not offered a case where discovery or investigative materials are ordered released under 239 when there's sentencing and a judgment occurring that are about to happen in a criminal case. Even the case law that follows Bradshaw on the balancing test, I don't believe there's one, I don't think petitioner has offered one, where the court ordered disclosure of materials like this when there was a pending case. The Bradshaw case itself, the court noted that there was no criminal proceeding happening, and more recently in the Las Vegas Metro case of 2023, that was the case of the file on the state trooper who was
Right.
had his wife murdered. There was also no criminal proceeding pending in that case. That was a key fact of why that file should have been disclosed. It decided not to pursue any criminal action against that individual. So what we got is the public interest, and I'm going to suggest that the public interest is vanishingly small at this point because what we're asking for is for this not to be published prior to sentencing, which, as you said, is scheduled for a week from today. So the court, I think, could do nothing. The court could clarify its order to say that the file should not be provided to Dr. Conrad prior to sentencing. That would certainly avoid the issue of a prior restraint altogether. We can discuss a prior restraint, which I will in turn, but so I think part of the balancing of the public interest is what is lost for the public interest by waiting one more week for a redacted version of this Tiburon report to go out.
And when you say the Tiburon report, you are speaking to the document that this court has already reviewed that's been redacted.
Yes, Your Honor.
Okay, not the file
No, I think there's still,
implicated by the Tiburon.
correct, I think there's still probably a lot of analysis to do with that larger file. No, the city's taken the position that an investigative report, a criminal investigative report such as this, the public interest in it is vanishingly small now with it being a week away, but also that what we're talking about releasing is essentially the narrative report of a crime and witness statements. And if I'm not familiar with the criminal case, the city's not a party to the criminal case, but if I was a defense attorney looking for a way to keep my client out of prison, I might like to argue that fair sentencing was jeopardized by a disclosure of a narrative of the crime. I'm not sure that it would succeed, but it seems like a risk that's not worth this court taking. I can see that going out into the newspaper and the criminal defense attorney looking at it and saying, no, I know what witness this is. The name's been redacted, but contextually we know who it is. That witness can be intimidating. I don't need to cast aspersions on the criminal defense attorney. There was something that was kept out of the criminal proceeding by a motion in limine that was referred to in the Tiburon report. And now it's out there. That could be argued as very prejudicial to sentencing. Or a witness. The sentencing will have witnesses. A witness sees something and gets spooked and no shows or changes their story based on something they see. So I think there are significant interests in non-disclosure, at least for another week. In the event the sentencing doesn't happen in a week, I think that vindicates the city's position that disclosure would be premature prior to the conclusion of the criminal case. The second argument, of course, is that the MPRA is unconstitutional as applied. Sort of a novel argument, expected to eventually get ruled on. As I mentioned, Your Honor could reach or not reach the prior restraint issue simply by what the court does with its order, but eventually I would suggest that a court will have to rule on the propriety of withholding this document up until now or up until the criminal sentencing. If not now, then certainly when attorney's fees are at issue, the court will need to rule on whether the city should have released all of this stuff 2 years ago or whether it was proper for the city to withhold the file until the case was over. And I would also look at this, Your Honor, with a view toward the fact that we will be here again. I can all but guarantee it, with this petitioner and this legal counsel fighting over whether criminal investigative files should be released prior to conclusion of a criminal case. Particularly where the petitioner has published that he believes he already won this case. On March 8th, there was a story that said that the city continues to fight the release of investigative documents despite losing on this issue. Now,
This is on the This Is Reno website?
correct.
I'm going to object, Your Honor, if that's in the record.
Say that again, Mr. Busby?
I'm not objecting if that's in the record.
I'll withdraw.
Okay.
The point remains, though, that I don't think there's been any finding by any court in this case that any of these materials are public records subject to disclosure. The remand simply instructed the court to review it, and the court reviewed it. And I'm here today suggesting that it should not be disclosed in any form publicly prior to sentencing. I can speak to the issue of prior restraints if the court would like to hear that.
I want to hear that, but just give me 1 minute. Okay, prior restraint. You can argue it prospectively, or you can wait until your rebuttal argument.
I'll wait until my rebuttal. Thank you.
Okay, all right. Mr. Dunagan, thank you so much. Mr. Busby?
Thank you, Judge.
Welcome.
If I may, I'd like to start with just an anecdote that I think is relevant to the issue, the importance of the issue that's before the court. Before the fall of the Berlin Wall, secret police in East Germany operated unencumbered by any knowledge of the public of what they were up to. After the wall fell, a lot of things came to light that some people found rather disturbing. I'd like to just offer one example. Often the Stasi would bring people in for questioning. They would sit you in a comfortable chair. They'd interview you. You'd leave. None the wiser to the fact that they would actually take the cover you were sitting on the chair, roll it up, put it in a plastic tube, and that was so the dogs could find you if you ever tried to get away. Nobody knew about that until the veil of secrecy was lifted after the fall of the Berlin Wall. And the laws at stake here, I'm not saying that City of Reno is the moral equivalent of East Germany. I'm just offering as an illustration of the importance of the principles at stake here when courts restrict the freedom of the press to report freely on the goings-on of the police. Now, the parties submitted a stipulation to the court, a proposed order for how this court was to handle the procedure of dealing with the voluminous public record at issue. And when that discussion took place, the agreement as we saw it was, hey, we're going to have disputes over what's public and what's not. Let's establish a procedure so the court can rule on those proactively. The discussion was not, let's allow the City of Reno to control what Mr. Conrad can report on and what he can't. The stipulations expressly, or the order granting the modified in-camera review process and modified briefing schedule, required the city to move for its protective order within 30 days of the court's order. It did not do that. In the meantime, the court issued its order after it conducted its initial review of the Tiburon report, and it said, hey, we agree, the court, with every single redaction the city has provided. The city provide that to the petitioner such that he can review it. The city refused to do that. We asked, provide this report, the city has refused to do that. We believe the city is in direct, is basically contempt. They haven't obeyed a categorical court order.
I have a question for you, Mr. Busby, because
Yes.
I find that this sort of hits on another point that you've argued in both the opposition to the motion for protective order and in the objection. So in the objection, and it's very similar in both places. So let me just go to the objection, because I think it appears sort of on the same page in both pleadings. In the objection, it's on page 5, and it starts at line 5. Go to your objection there. And it says, on March 5th, 2024, this court entered its order after in-camera review. Okay, you see that paragraph?
Yes.
Starting at 16. Troublingly, for the petitioner, and I want to address the issue that's in the objection, and I want to address how it ties to the assertion you just made, which is the city's refusing to turn over the report so that it can be published. Troublingly for the petitioner, the objection says, and I believe this language is directly out of the opposition as well, the court's March 5th, 2024 order directs that the report is to be provided to the petitioner, quote, for the limited purpose of allowing petitioner to identify portions of the larger investigative file pertaining to RPD case number 182-6148 that he seeks to inspect, close quote. The pleading goes on. This directive by the court, insofar as it imposes a prior restraint on Conrad's ability to report on the Kerry matter and a redacted report not yet released, is unconstitutional. Okay, so first of all, I'm curious about that statement, and it, like as I indicated, it bleeds over into the remark that you just made about the state refusing to release something that the court has ordered released. The language that you have in the quotation there on page 5 that you say is per se unconstitutional because it imposes a prior restraint, and that specific language is, for the limited purpose of allowing petitioner to identify portions of the larger investigative file pertaining to the RPD case that he seeks to inspect. On January 9th of 2024, the parties, as we've noted, someone has thus far in this hearing, filed a stipulated request for an order, okay? And that document had attached to it Exhibit 1, and Exhibit 1 was a proposed order, okay? Exhibit 1 was a proposed order, and that proposed order at page 2, paragraph 2, line 3 says, or let's just read the paragraph. It says, paragraph 2 on page 2 of the proposed order attached to the party stipulation. This is a joint order the parties are asking this court to consider to address the process. Following its in-camera review, there it is. Thank you, that's helpful. Following its in-camera review of the report and respondents' proposed redactions, the court will provide direction to respondents to furnish a copy of the report, we're still talking about the Tiburon report, to petitioner, including redactions that the court preliminarily deems appropriate for the limited purpose of allowing petitioner to identify portions of the larger investigative file pertaining to RPD case number 1826148 that he seeks to inspect, and then it goes on, and portions that he does not seek to inspect, which the court there need. Okay, now, that language, as you put up on screen, and I have here in the order, is what the parties came to me with.
Indeed, Your Honor, and I'd like to
Okay,
address that.
so let me finish the question, as long as it may be. Thereafter, I accepted the recommendation of the parties, and on January 18th, 9 days later, I issued an order that had that language verbatim. And so, after the in-camera review, according to the order, the process that the parties had jointly recommended to this court, following the in-camera review, paragraph 2 right there on screen, following its in-camera review, I included in the order that I then issued on March 5th, 2024, that uses that exact language, which you say in your pleading is unconstitutional as a prior restraint, even though I'm doing exactly what the parties jointly requested, you on behalf of your client, Mr. Dunagan, on behalf of his. So first, I don't understand why you argue this in both the objection and the opposition when it was a process and the exact language agreed upon by the parties, number one. And number two, the parties agreed that after the in-camera review occurred, the report was to be provided to the petitioner for the limited purpose of allowing the petitioner to identify portions of a larger investigative file, not for the purposes of going public with it, for the purposes of treating it as a public document which had been released. So I have, on two fronts, I have questions for you. Why is what I did exactly what the parties asked, an unconstitutional prior restraint? And why is Mr. Dunagan in violation of a process that this court believes the parties stipulated to?
Your Honor, you're getting exactly to the point I wanted to get to. So I appreciate you sharpening in on that point. And I think that the distinction arises because when the parties entered the stipulation, I think we were contemplating that the court would accept some of the redactions in the Tiburon report and perhaps reject others. So there would be outstanding issues of fact about whether what the court was being ordered to be given to the petitioner would contain information that the city of Reno might object to. But instead of doing that, the court accepted every single redaction. So our position is, when it did that, when the court did that and issued its order, that document became a public record. It contains every redaction that the petitioner requested. And plus, if you read paragraph 2, which contains the language you're referring to.
Hang on, wait, I want to read paragraph 1. Okay, all right, it doesn't say that. It doesn't say that the parties had it in their mind that the reason this was being drafted this way is because the court may accept some of the redactions and not others.
It doesn't say that expressly, Your Honor, but I think it's a reasonable inference given the context and the contents of paragraphs 2 and 3 read together. If you take a look at paragraph 3 of the court's order that the parties asked you to approve, it said, hey, as soon as the court issued this order, you guys have to meet and confer as to a stipulation regarding the timing.
The timing.
Yeah. And the respondent shall, within 30 days of the issuance of the order, file a motion for protective order regarding the contents of the report. That never happened.
Right, that's not the point though yet, we're not there yet.
Okay.
Upon issuance of this order, the party shall promptly confer to explore a stipulation regarding the timing of petitioner's publication and/or reporting on the copy of the report that is furnished to petitioner following the court's in-camera review. That's the part, I think, that relates to paragraph 2. That's the next step.
But it was to.
But no, we're gonna get to the fact that this meeting was outside the 30 days and they filed, it's not timely filed. The motion for protective order is not timely filed. I don't think Mr. Dunagan disputes that.
Well, that's the whole basis for our claim of the prior restraint. Essentially, we foresaw that we might have some disagreements about this because there might be some materials that the confidentiality of which would be disputed at this point. And
But then, if that's the case, how could you have the meeting contemplated by paragraph 3 like you did before I released the my in-camera review? It doesn't, your argument's not making sense to me.
well,
You did not tell Mr. Dunagan when he said, or I don't know who reached out to who. By the way, the obligation was the parties must promptly meet and confer. Not the city has to reach out, or the petitioner had, the parties had an obligation. But what I don't understand is, if the first thing you said is true, which is, hey, this whole limited purpose thing was because, Judge, you may not agree to some of the redactions, you may want more, you may want less. I don't understand how, if that's the case, and that's the basis for the language that the parties agreed on regarding the limited purpose of allowing petitioner to identify portions of a larger investigative file, the only reason, according to the stipulated order, that the city was to produce the Tiburon report after the in-camera review. If the parties thought there was going to be a debate about the redactions, I don't understand why the parties then agreed to meet February 22nd of 2026 to discuss what was going to be at issue after I issued the in-camera review when I hadn't issued the in-camera review. This is going to be hard to write. Right, okay.
it springs to mind, sorry, have you heard of Soren Kierkegaard? Love the guy.
Yes.
Great quote, okay. Life has to be lived in going forward, but it can only be understood in reverse.
Right.
Love that quote. I think that's the precise situation we have here.
Okay.
I don't think either of us thought that the court was going to accept every recommended redaction that was put in the draft of the Tiburon report. And we wanted a mechanism to deal with that conflict when it occurred. And we were going to confer about it within 30 days. Basically, after the expiration of 30 days, I reached out to Mr. Dunagan and I said, hey, we talked about this. This language is concerning to me. The sentencing appears to be coming up. My client's very likely going to want to report on this. What are we going to do? And that's when he filed his notice of intent shortly thereafter to file for a protective order. And here we are. But as I said from the outset, it was our intention, basically, the intention behind the document that we submitted to the court was, hey, let's have a formal process for resolving this exact type of dispute should it come up. And we thought the 30 days accommodated specific time to address any problems we would have, with paragraph 2. It's difficult to foresee exactly how these things are going to shake out, but when the court issued its order ordering the city to turn this stuff over to us, with every single redaction the city requested being approved by the court, it's our position that at that point, that document became a public record. Everything the city asked for was taken out and redacted. So what is it? I mean, if it's being provided to us for the purpose of identifying portions of the larger investigative file, I mean, that would make sense if there was still a dispute about some of the city's redactions, but there wasn't anymore. The court approved every single one of them. And so that being the case, we don't think there's any rationale for, at that point in time, preventing Dr. Conrad from looking at the contents of the Tiburon report and reporting on it if he thinks any of it's newsworthy. And I understand.
So I want to back up for a second, just,
Sure.
it helps me to give you my understanding of what you just said. So notwithstanding some of the issues we've already discussed, we get to the finer point that you're making, which is, once I issued it without challenging any of the redactions that the city made, at that point, it's Dr. Conrad's position that the document is now a public record.
Correct.
Because the city made their redactions, I said those redactions were fair, and as a result of that, now that document's a public record. Okay, now, that could have happened. That was a scenario that was possible when the parties provided me the stipulated order for the process, right?
I mean, it's within the realm of logical possibility, yes, Your Honor. And in order to accommodate that logical possibility, paragraph 2, or paragraph 3, I'm sorry, required us to confer and for the cities to submit, proposed protective order.
Wait, I want to go back.
Yes, sir.
And Mr. Busby, I promise to let you finish, and you can even start over if you want, because I've interrupted you. But once it became a public record in Dr. Conrad's opinion, because the court, the court approved the city's redactions. Now, to me, the next step is, although untimely, talk to me about the protective order. Even if it's a public record, are you saying it's not subject to a protective order?
I don't think any public record, Your Honor, can be subject to a protective order.
Then why did the parties stipulate? Why did the parties stipulate to language that says, in the event that a stipulation is not reached, respondent shall, within 30 days of the issuance of this order, file a motion for a protective order. The parties agreed to that. So in other words, it was always a possibility that the court would look at the city's redactions and say, this is fine. Okay? That is a scenario that can occur under the confines and the terms and conditions of the stipulated order that this court adopted almost verbatim, that the parties submitted. It's still, so assuming for a second that your argument is sound, in other words, the court agreed with the city's redactions, now it's a public record. The order still contemplates that even if that occurs, albeit timing is still an issue, that the city has a right to file a protective order. Am I not reading that correctly?
I would disagree with that inference, Your Honor. I don't think it says that directly. Basically, we didn't expect the court to move so fast, frankly enough. We didn't expect sentencing.
Funny, I thought it was moving slow. It was only 285 pages and I read every one of them.
Basically, my thought was 30 days would be enough of a window for us to resolve any disputes about what should be protected and what shouldn't. And that's kind of like, that was the first thing I said, if the board recalls. And that's how we framed, how we viewed this document when we were reading it and signing it back.
In January.
Yeah, a few months ago. And I understand the court's concern that the language is ambiguous as to this particular, we viewed it as an unlikely scenario that potentially would occur. But the underlying principle for us was to create a mechanism whereby the city, if they believed, let's say the court said, I agree with 50% of your redactions and I disagree with 50%, provide a report to the petitioner. Well, the city would have a mechanism to deal with the 50% that they still disputed through the protective order. But that didn't happen. everything the city asked for, it got. And that's,
I actually would look at it the other way. I thought the city was, one of the reasons that the in-camera review went the way it went is because I thought the city was very, I want to use the right term. I thought and generous is the wrong word, but I thought the city was very conservative in the redactions.
well, that being the case, if there's materials in there that the city didn't want to redact it, then what principle, what right is at stake that would limit Dr. Conrad's ability to report on it, especially after the court has ordered that he receive it?
So, for the limited purpose of doing what the party said they would do, which is make a decision about the timing of the release, or make a decision about the broader file.
I guess, the question really turns on whether the court is going to accept our premise that the purpose of the stipulation that was submitted to the court was to create a mechanism, formal mechanism, a procedure for resolving disputes as to the confidentiality of the remaining records should they occur.
Right.
Now, we're saying, and I understand the language can be read either way, but in our view, once the court determines that, hey, the city's redactions are fine, the rest of it is something, that at that point there shouldn't be any limits on Dr. Conrad's ability to report on it. And that if any limits were imposed, under the language in subsection 2, that limit would be imposed to information where there was still a dispute as to whether, the record should be in the public. And we're, when Mr. Dunagan and I conferred about this, the narrative changed substantially from procedure to substance. To, you shouldn't be reporting on this because there's going to be some activity in the criminal case.
Which is the basis for the protective order.
Yeah, and hearing that, the alarm bells go off for anybody who does First Amendment law, and we say, "Whoa, we can never agree." Of course we didn't intend to. And that being the case, we wanted to bring the issue to the court's attention as soon as we possibly could, because if the court is going to impose something like that, it needs to do the required constitutional analysis, and the city has to meet the very, very high burden of what's required when the court is going to tell a journalist what they can and can't report on. And there's really been no effort in that direction made by the city that we think passes constitutional muster. All the arguments that they make may be perfectly valid, but also fail when the court considers the much more fundamental constitutional principles at stake in this case.
Right.
And so, if you have any more questions, I'd be glad to answer them. But I think that's the crux of our.
Okay, just a couple of things. I want you to know, when I first read the stipulated order that the parties had agreed to, and I know both of you, and I know the capacity of both of your brains, and that's big. I have professional experience with both of you, and I know that you're both on top of it. And so when I read that, I will tell you, when I read the stipulated order, the first thing that occurred to me when I read paragraph 2 is Dr. Conrad has no interest in publishing the narrative, because the narrative is only being used. That's the way the stipulated order read to me, is that the narrative is only being used so that Dr. Conrad can get into the big file. The court's has another in-camera responsibility pursuant to the stipulated order. But so that Dr. Conrad can actually get into the bigger file, because that's the way paragraph 2 read to me. I'm going to do the in-camera review, and it's going to be released to, provided to Dr. Conrad for the limited purpose of allowing him to review it so he can decide what he wants out of the bigger file. Reading that order, it never occurred to me that the parties were going to come to this court and say, or that Dr. Conrad was going to come to the court and say, by the way, we want this released. And so, yeah, I mean, that's the way paragraph 2 reads.
I mean, looking back at it now.
Right.
Seeing someone who wasn't part of the conversation.
Right.
Your point is quite valid, it makes perfect sense.
Okay, so.
But Dr. Conrad, there's another issue is we don't even know what's in there. Likely, it's going to be a very similar narrative as to what was contained in Sergeant Johnson's declaration, which was filed into the public record, which we already have. And that being the case, it's probably part of the something but a nothing burger. But the fact that the city is being so adamant about not having this disclosed, so far insofar as it's willing to violate a court order, the court categorically said, turn this over to the petitioner.
For the limited purpose of having you identify what you want in the bigger file. That's the way the order reads. That's what the stipulated order said. But let me ask you something. Oh, go ahead. No, I have my thought. You go ahead.
I'm sorry, Your Honor. I never represented to Mr. Dunagan that Dr. Conrad was going to violate the court order. And in fact, thinking about it now, what would have made sense is for him to provide it to me. Say, we're going to file a protective order, and give this. Let's have a discussion about it. But that didn't occur. So we're shooting in the dark, and whenever the government withholds something like this from a journalist, especially in light of a court order demanding that it be turned over, it's going to send off the alarm bells.
Okay, so a couple of things. First, what do you think of the strength of Mr. Dunagan's argument about the sentencing? It's a week away. What about that? And he provided some example or two or general prejudice to the defendant Carey prior to his sentencing, and then today he came with a couple of others that are additional, which is this. You know enough about this to know that the contents of that police report implicate some individuals who, for lack of a better term, are victims. And Mr. Dunagan's point is, if this is what I hear him saying, this is not the court's argument, Mr. Dunagan, if I'm putting words in your mouth, you can tell me during your reply, is if this gets out there and it becomes a general spectacle and the members of the public now all want to participate, which they're entitled to do, can the state now not rely on its witnesses because they don't want to be in a proceeding that's turned out to be highly publicized, and as a result of that, parties are prejudiced because now their witnesses don't want to come forward. They don't want to testify at the sentencing.
Yeah, I'm not sure if there's any, there's been a specific example of that, and that same kind of logic can be applied to any time a criminal proceeding is being conducted, or a criminal investigation is open, or any of those things. And in determining whether a public record should be released based on that objection, the court has to weigh that against the public's interest in disclosure and knowing what's going on. This is a sensational case. This involves a public official who was up to no good. One of his victims is a federal magistrate judge. It's an extraordinary case. And the public, in Dr. Conrad's mind and in my mind, the public has a very strong and compelling interest of knowing what happens when someone from within the system, in this case Washoe County Sheriff's Office, engages in misconduct and is prosecuted. The gravity of that, we think, is substantial. And we're litigating lots of these cases. The city of Reno and I in Washoe County, there's a push for getting the courts to make rulings based on broad claim of confidentiality of records in open investigations and bench trials, basically pushing the Donnery standard to the extreme where it creates a categorical exclusion. But the problem is, Donnery was issued in 1990. Subsequently, in 2007, the Nevada legislature reined that in. They passed amendments to the Public Records Act. They said you have to construe every exception narrowly. And the Haley decision, which was issued subsequent to Donnery, acknowledged that legislative change in purpose and intent. And so really what the city and the county and others need to do, if they want a categorical exception to cases in which a criminal prosecution is ongoing, or if there's an open investigation, the legislature needs to solve that problem. And that was actually brought up in oral argument in the case of Dr. Conrad that I did just 3 weeks ago for non-block Nevada Supreme Court.
Oh, no kidding. Will it be a published decision, do you know?
I believe so. It was on block.
What's the case, what's the party's name?
It's
I just want to keep an eye out for it.
Conrad v. Reno.
Oh, same thing, okay.
Mr. Dunagan, my friend on the other side, made excellent points. And
Did you both argue that at the Supreme Court?
we did.
The two of you?
Yes, Your Honor.
Yeah, that's great.
These are difficult issues, but we would caution the court from embracing this kind of categorical exception when there isn't a specific instance brought before the court. There's no one on Mr. Carey's behalf here arguing that these records shouldn't be released. We think largely they'll be consistent with what's in Trimson Johnson's affidavit that led to the arrest, which is in public. So, we don't think they've met the threshold. They can always throw out these speculative examples under the Donnery test, but unless there's something concrete, a specific witness who might be intimidated, a specific instance of a threat to someone or something that might interfere with that case, we think these documents are public records, especially insofar as the court's already reviewed it and determined that all of the city's claimed bases for confidentiality are valid. And so now it's up to us to challenge those as soon as we get a hold of the report if we think a challenge is pertinent to the law.
Okay. Mr. Busby, thank you so much. Mr. Dunagan, let's start where he left off. Specific instances, what do you think about that? And then he made an argument about the overwhelming weight of the public's right to have this information.
I think much of what Mr. Busby said cuts in favor of non-disclosure, Your Honor. That's because that public interest, that extreme, intense public interest, can be served next week, assuming that that sentencing does occur. But much of the argument, like the arguments throughout this case, and like, if I may, the Berlin Wall analogy that Mr. Busby opened with,
Something.
here's the thing. None of that it implicates the constitutional rights of a U.S. citizen to have a fair trial. And that point has been largely sort of unaddressed by the petitioner and undealt with. I think the timeliness argument, which I first to admit, it was not timely under the order, but that's an excellent example of why due process is not being served by the NPRA being the mechanism to get these records. In other words, the court potentially can find that because I blew a deadline, that Dennis Carey's constitutional rights should be abrogated or subjected to some kind of threat. It's not up to me to say what in there certainly will prejudice the case. It would be up to the parties in that case, I think. Mr. Busby's correct. There's no state prosecutor, there's no criminal defendant in this courtroom. That's the problem with the NPRA as applied to these files. That it illustrates it perfectly. And the judge, with all due respect to Your Honor, I know you read the pages in front of you, but this court is not the best situated to determine what in that file should be read by the public. It should be the courts presiding over the criminal case that knows what the prejudices might be. None of us are in a position here to do that. And so that's the basis of sort of this unconstitutional as applied argument. If I can address the bit about Don Ray v. Bradshaw. Don Ray v. Bradshaw was decided in 1990. And as Mr. Busby said, much of it has been sort of clarified and elaborated. But one of the things that has changed since that case was decided is that in 2013, NRS 239 and the long list of exceptions added NRS 179A to the list of exceptions. It wasn't there at the time that Don Ray was decided. That's why that court had to do a balancing test, because they didn't know if there was per se, things that were per se confidential. And so, in a sense, that first holding in Bradshaw, I think, probably needs to be revisited and hasn't been. Because I think there's a pretty good statutory argument that there is public policy interest in maintaining the confidentiality of police investigative files and criminal discovery. If I could speak to the First Amendment argument a little bit. If petitioners write about the test for a prior restraint, I don't think there would be any such thing as a protective order. In other words, just once a court says, give this to the person, they can publish it in the newspaper. There's hundreds of cases where there is a limited restriction on publication or discussion of items that are criminal discovery materials. In the test, if you look at prior restraint case law, they all look at, is it too overbroad? Is it essentially a gag order? Is the court telling the media, you are never to publish on any of this? And no one is even telling Dr. Conrad now that he can't report on this case. Certainly he has access to the case, but no court has said that there is a First Amendment right to criminal discovery material. I would add, Your Honor, that Dr. Conrad is a party to that criminal case and could be having that fight over criminal discovery materials in that case. But as far as I know, after filing as an intervener, never tried to get any of those materials. And that makes sense to me because if I'm the media, the NPRA is a much easier mechanism to use. He can come to civil court and ask a judge that's not familiar with the criminal case, in a case where he doesn't have to face three opponents, and the state's interest in a fair trial, and a criminal defendant's interest in a fair trial. I'm supposed to defend Dennis Carey's constitutional rights. It's a bad position to put governments in. With respect to the stipulation, I think the court reads paragraph 2 of that order the same way that the city reads it. And I can make a representation that the city would not have ever conceded that the report was a public record. Governments are trying to draw a line to cut back not just on these threats to due process posed by these questions, but also just the volume of public records requests that governments get. It would be a great use of resources if a court would say criminal discovery material is not subject to the NPRA. Whether this court says that, I'm sure then the Nevada Supreme Court would be listening to that question. But if that were the case, it would allow local governments to run a lot more smoothly. I'm not sure if I have anything else wrong, unless you have questions.
Mr. Dunagan, question for you. Let's assume that the sentencing is not an issue. Let's assume that the sentencing is September 1st of 24. If this court, without that, is it your understanding that the way the order was supposed to be read was once the court was finished with the in-camera review, the document was supposed to be turned over to the Tiburon report, let's call it that, because that's what it is. The Tiburon report, the narrative, was supposed to be turned over to Dr. Conrad for what purpose? After the court's in-camera review.
Just like the order says, for the limited purpose of identifying other parts of the record. September 1st is a great example because I think I don't envy the court's review of everything that's coming out in this file, but when the city entered into that stipulation, we had a meet and confer after the last hearing that we had, and we had the detective trying to explain to Dr. Conrad what this stuff is based on like an index, and all of us in the room realized this is going to be a lot easier for him if he can have the contextualizing document. This sort of Rosetta Stone to that file that this.
There was a little bit of that conversation when we were all together also at the last reporting hearing.
And so the city would have been careful to never concede the point that that document, even in a redacted form, is appropriate for public disclosure. And the parties knew at the time that we weren't going to agree on the scope of a protective order. That's why that language is in there. I mean, I will represent that. I did not expect Dr. Conrad to necessarily agree to use the report the way that we thought it should be used. If I thought that was a risk, and if I thought that this court was going to order disclosure of a redacted report, I wouldn't have offered to enter into that stipulation.
This is a fine point. Mr. Busby, I'm going to come to you after this because I, am interested in this. So even if, then what's the need for the protective order? If the argument of the parties is, the way that the order was supposed to be read is they're only getting it for the limited purpose of now identifying for the city what they want to see in this room full of boxes. If I grant the protective order and say the deadline is the day after the sentencing, so it's April 2nd, the judgment of conviction enters April 3rd, it's over. Okay, the sentencing is come and gone. And whatever arguments that the city had with regard to prejudice have been addressed. You're going to turn over the Tiburon report to Mr. Busby and Dr. Conrad at that point, right?
Oh, yes, Your Honor. In
Right.
fact, I would withdraw the motion for a protective order at that point. Because I think at that point, he can publish the redacted Tiburon report without prejudicing the trial and sentencing.
Okay. Mr. Busby, this is all very important. Oh, Mr. Dunagan, anything else?
You
Yes.
didn't dismiss me, Your Honor, so I
Yes,
want to make sure you didn't have any questions.
thank you. You're fine. Mr. Busby, it's all very important. It's Mr. Dunagan's motion. He's going to have the last word, but I do want this is evolving and it's very interesting. So go.
Your Honor, the fact that Mr. Dunagan, my friend on the other side, just conceded that they have no issues releasing the report the day after the sentencing reveals, the truth of the matter, which is the withholding of the report is for purposes of control. And the purpose is to control what Dr. Conrad, indisputably a member of the media, can say or not say prior to a certain date and time. And that's where we see the constitutional issue really being revealed. guess, I think that's the crux of the issue. If any more questions, we're glad to answer them. But we obviously see that there are two sides to this issue. But we think the weight, clearly under the Don Ray test and everything that's come after that, including the CCSD decision, the Las Vegas Metro decision. In this case, because of the underlying facts, weighs on the side of disclosure. Even if the court were to just analyze this under the Public Records Act and disregard all the arguments about constitutionality, which we think are incredibly important. And also, strict scrutiny requires detailed, specific analysis. It can't just be blanket. In general, we think this is a bad idea, so we're going to preclude the news media from bragging.
Doesn't work, that won't fly.
The Falcone decision, I'm not sure if you're familiar with that, just came out, another case of mine. The court applied very similar principles to closure of divorce proceedings and court access. It wasn't about documents so much, but the same principles apply. If you're going to exclude people from access to documents or proceedings,
It was proceedings in the Falcone case, right?
It was, Your Honor. It was the court ruled that NRS 125080, which was a divorce statute that allowed either party to raise their hand and close proceedings, was unconstitutional on its face, as well as several other regulations that were passed by the family court. And, that decision is changing fundamentally the way that divorce proceedings work in Vegas and all over the state. But it reinforces that the Nevada Supreme Court use our laws as being subject, our state closure laws, public records laws, etc., subject to strict scrutiny analysis when it passes to be excluded from information relating to court proceedings. And that's under the Press Enterprise decision, Globe newspapers decision, and the state decisions escaping me. It's been very difficult work today. The last point I'd like to make in particular case was, but there's a state court case which implements those decisions. That's solid.
Solid?
The solid decision.
Okay.
And I would like to provide a citation to the court.
Okay, Mr. Busby, thank you so much. Mr. Dunagan, it's your motion, sir. You have the last word.
Thank you, Your Honor. I'll be brief. This isn't about control. The NPRA puts government entities like the city of Reno in a really awkward position of balancing interests. That's what they gave us, balance the interests. And that's what we're trying to do. Dr. Conrad has one interest that he's trying to serve. I think it's a noble interest. I don't take issue with his interest. But we're in the position of saying this might violate somebody's due process. We're doing the best that we can do. This isn't a control. This isn't because I can. That's the city's position on that point. As to strict scrutiny, I'm trying to rush through the briefing on this case. I believe I addressed that I don't think strict scrutiny is appropriately applied here. Protective orders are constitutional if they're narrow enough in scope. And we're talking about potentially a protective order that dissolves a week from today, potentially. I think that's very narrow in scope, and I think it meets its purpose. In terms of the right of access, there's plenty out there about the press's right of access. But I gave in my opposition, or in my reply in support of my motion, I gave some case law that says that the First Amendment and the 14th Amendment do not mandate a right of access to government information or sources of information within the government's control. Courts have rejected the argument that the First Amendment compels access as a constitutional matter. I'm not able to give a full strict scrutiny lecture today, but I think you'll find that that is not the appropriate standard for the type of protective order that we're asking. And the go over in the Bundy case that I put forward, I think is a pretty good example of one that passes constitutional muster without strict scrutiny.
Okay, thank you. Excellent, very good. I wanted to learn something today, and I did. Council, thank you so much. Definitely have our work cut out for us here in D1 on this one. I am very sensitive to the fact that this sentencing is coming up. I know it's an important date for Dr. Conrad, and so I am going to endeavor to get something out as quick as we can. Thank you all very much.
All rise.